Let's call the case People versus Serrano Johnson.
Public Defender Chelsea Vergils with and on behalf of Serrano Johnson. Mr. Johnson, please state your name.
Serrano Johnson.
Before a single ruling is made, this courtroom is already sitting on a powder keg. What looks like a routine probable cause conference quickly turns into a masterclass on how not to handle a bond violation. The defendant admits to drinking while on bond, but what really grabs the judge's attention isn't the alcohol, it's the story, or rather, the shifting versions of it. This judge isn't just listening, he's calculating. Blood alcohol levels, timelines, and logic all come into play as the defendant tries to walk a very thin line between confession and denial. And here's the key question for you. Is lying to probation worse than the violation itself? Because in this courtroom, credibility is currency, and once you spend it, you don't get it back. Watch closely, because every answer from here on out pushes this case toward one inevitable outcome.
He had old duels. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That is correct, Your Honor.
Then why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No. Hey,
I had O'Doul's.
Are you
I had
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got
The
it.
story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at, you would have had to have 25 O'Doul's in an hour.
No, I didn't have
in
that.
order to reach that level.
Sure.
And could not have used the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't even, you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
Regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders.
Well, I don't think he's going to have a choice on that, quite frankly, Mr. Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really? No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he's asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded.
Address bond, Your Honor.
Well, what are we going to be doing on the case first?
I got your green sheet. I forgot to give it to you.
All right. You're asking for an adjournment of the proper
Yeah.
cause.
Yes, Your Honor.
I'll give you a date and moment depending on the outcome of your bond motion. Go ahead.
Your Honor, I've provided the court with a letter from Second Baptist Church, Reverend George Waddles. The pastor is present here in court today along with
see you.
my client's
Hello,
family
Pastor.
members.
Go ahead.
If released, he would live at apartment 1 in Ypsilanti. By profession, he's a chef. He's been a resident of Michigan approximately 20 years. Like I said, he attends Second Baptist Church. He also volunteers at Hope House. And Your Honor, he's a caregiver for family members. So he has a lot of things going on. He volunteers in his community. I understand from the last hearing that he was not candid with the court as to his consumption of alcohol. But
Well,
and I'm not,
not candid would be an understatement. I mean, he just outright lied.
well, I wasn't there.
That makes it no less a lie.
I'm asking if you want to hear from him.
I'll
A humble
certainly-
apology.
I will certainly hear from him, but not if he's gonna sort of spew that garbage he was giving me the last time, because that's how he ended up in custody.
I apologize, Your Honor. I panicked. I apologize. Yes, I did consume.
Pardon?
Yes, I did consume, of course. But yeah, I panicked when I was talking to the guy. I apologize for our last encounter.
You consumed alcohol and when I tried to get you to just tell me that, you just lied to me. Right?
Yes, I tried to go back and you told me.
Pardon?
I tried to go back on it, but it's too late. I had already said it. So, yeah. I apologize, Your Honor.
So on the date that you drank, what happened?
What was the trigger? What made you drink?
Working on somebody's funeral arrangements and drink a couple beers, drink a few beers.
Okay, so
So
did you have any O'Douls
at first, but
at first? Okay. How many O'Douls did you have?
6.
6. And then you had how many?
Labatt's about 4.
4.
Sure.
Okay, now you know that's different than what you told me.
I was trying to tell you, but you told Mr. Allen
You were trying to tell me what?
nothing. That's what I
No,
told
no, 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 no. Let me tell you what you said, because I remember it very clearly. You told me that you had 6 O'Douls. I told you to get to the levels that you were, if you were just drinking O'Douls, because you were insistent on that, you would have had to have a little over a case of O'Douls. Remember that?
Yes.
Then, at that point, you realized, well, he looks stupid, but he's not. And then you started telling me that you had 2 beers. Remember that? What?
Yes, Your Honor.
And I knew, given the level that's on here, that wasn't true. Now, the other things that you told me was that you were in treatment. Remember that?
Treatment. He's trying to go to treatment.
Well, okay. Yes.
I'm just trying to,
I don't understand the question.
I said it to me.
he said at the
Did
last,
you or did you not tell me that you were
I wasn't
in
there.
treatment or had started treatment?
We were looking for a place to go to treatment. That's where we're starting. We're trying to go. Yes. My insurance is different.
Let me ask you this. When you made the statement about treatment, were you trying to get this court to believe that you were in treatment?
No.
You're saying no?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
Self-incriminate myself. I don't know what you want me to tell
You
you.
don't want to self-incriminate yourself?
Already done.
So see, okay. And I know you know this, but I'm just going to remind you. That's what happens when you lie.
And I apologize.
I know a whole lot more than it appears that I know. And the moment you told the people at Community Corrections about O'Douls, I knew you were lying. That was my first start. Now, if you can tell me that you can put down about a case and 2 or 1 beer, about 25 beers, and not go to the bathroom, because that's the only way that was going to happen with O'Douls.
That didn't happen.
Yeah, so that's was kind of the stupidity of the lie. And then it just got worse for me.
This is the moment everything comes full circle. The judge makes it crystal clear. The problem was never just alcohol. It was intentional deception. Courts expect accountability, not perfection. But once the judge concludes that the defendant wasn't merely omitting facts, but actively trying to mislead community corrections and the court itself, trust completely collapses. Legally, bond is built on one foundation: honesty. When that foundation cracks, judges have broad discretion to revoke bond, remand a defendant into custody, or impose stricter supervision. And that's exactly what happens here. Jail becomes the consequence, not as punishment for drinking, but as a direct result of repeated dishonesty. Ultimately, the court does extend one final opportunity: release on a substantial personal recognizance bond, 24/7 scram monitoring, and mandatory treatment with a hard deadline. Miss it, and a warrant follows. Now, let us know, did the judge strike the right balance between accountability and rehabilitation? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, And don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Needs treatment, Your Honor, and I did have a chance to look at the letter that Mr. Brown provided that was from Mr. Johnson's pastor. It is a lovely letter and talks about the lovely things that Mr. Johnson has done. And the people aren't arguing that Mr. Johnson is a bad person at no point. That we allege that, we're alleging that he committed a crime, and it would appear that perhaps the root of that could have been an alcohol addiction, Your Honor, and we think about treatment, that situation could reoccur. And it's not clear that Mr. Johnson understands that or the need for treatment. So we do have some concern there.
Anything else, Mr. Brown?
No, Your Honor.
Johnson, here's what I'm going to do. I'm going to first of all adjourn his probable cause conference to August 7th, 2025, 9 a.m. With reference to his bond, I will set his bond at a $25,000 personal recognizance bond. On your release, you are to report to the Department of Community Corrections for placement on a scram tether because you were on a
Correct.
You're going to go on a scram tether, so I'm going to monitor you 24/7 for any alcohol consumption. I'm also going to order that within the next 10 days, defendant is to be enrolled in treatment. He is to notify the court that and the prosecutor's office that he is in treatment.
How many days?
He's got 10 days to do it. If he doesn't get in, I'm issuing a warrant, or he might as well just come over to jail and turn himself in, quite frankly, because I'm going to issue a warrant and I'm going to have him picked up.
Understood.
You understand all of that, sir?
I do.
Thank you.
Thank you, Your Honor.
No, just, we'll do that. Okay. Thank you, sir.